cell phone. They claim that this cell phone was being used for marijuana or whatever. It turned out that they unlawfully searched that cell phone, even though it wasn't Ricardo's, it was in Ricardo's vehicle by one of his passengers. And they went in and searched the phone without a search warrant. There was a motion filed to suppress the evidence because it was unlawfully searched by the officer without a search warrant. Do you understand?
Point of interest.
Yeah.
Clement seemed to have a strong breathing situation. Can he turn off his mic when he's not speaking? Because it's kind of
Oh my
a
God.
bit disturbing. Clement, no offense to you, know. I'm just saying sometimes you may not realize it, but you're breathing heavy in the mic. I don't know if it's
I have a mic. I have a mic. I have a mic. I have a mic around my head, so
yeah, right. So when you're not
it's
using it,
down like a driver. You know those drivers' mic, truck drivers' mic that you have,
okay, yeah. When you're not
and it's
using
right
it, just
beside
turn
you.
it off. Turn it off when you're not using it.
Really, I know you're sensitive to my breathing.
Okay, it doesn't bother me, but it's fine. So then
It's a bit distracting,
I
though. Yeah, all right.
okay. So but then there's pre-trial discovery, which I already discussed, which is mandatory. It's mandatory that the state must provide all evidence against the defendant, including exculpatory evidence. Do anybody know what exculpatory evidence is? I need you guys to participate. If you have to Google it and come up with the definition, give me the definition of what an exculpatory evidence is.
All right, let me do that.
Huh?
I'm gonna Google it.
So exculpatory is exculpatory. Exculpatory. So if anybody have a legal dictionary, Google our dictionary or whatever, look up the word exculpatory evidence and tell me what you think it is.
Tending or serving to clear from alleged fault or guilt.
Exactly. So any prosecutor who has reason to believe that the person was innocent and they have those evidence and withheld it from the defendant of the evidence proving that this person was innocent, a prosecutor can be held accountable for deceiving the defendant, and the defendant can come now and file charges for a motion to dismiss the case or any other thing. Anytime a prosecutor failure to release exculpatory evidence, you can actually sue a prosecutor in their individual capacity for hiding evidence against the party that can prove that the defendant is innocent. So yes, it's basically evidence that can prove that the defendant may be innocent and in fact not guilty.
So you were saying that they suppress the evidence, right? So
no, it's different. Motion to suppress is for evidence that was unlawfully taken. Here, exculpatory evidence is evidence that can prove that maybe the defendant may not be guilty. So it's a way to prove, it's evidence that they have in their possession that tends to negate that this defendant did not commit the crime they allege. And it could be that they have a video camera of the officer the officer said they were on Marsh Road watching traffic, and the video what they received saw the officer was not where he said he was. That's exculpatory evidence right there. And they might hide the camera and don't want to produce the camera, and then you'd have to say that's exculpatory evidence. The case should be dismissed for the failure of the prosecutor to produce the evidence.
Okay.
I'll give you an example.
Okay, go ahead.
If say there was a shooting in Toronto, and somebody saw somebody that resembles somebody, so they reported to the police. Say, yes, I saw that person on the scene, right? But the prosecutor, after the investigation, he has the gentleman passport to know that he was in Jamaica at the time.
Yes,
he wasn't here. But she held the passport. That is a proof to say that he wasn't in the country, and she did not. And
exactly. And yes, you are absolutely correct about it. You are absolutely correct. So then the only evidence they really don't have to give you is called work product. Work product is they're doing their own investigation and legal research. So let's say the prosecutor go out there and find some some research, some case laws that could help her case. She don't have to give you that. That's her work product, right? However, they must disclose their witnesses. Vice versa, the party reciprocate who their witnesses will be. If the prosecutor believe that maybe the defendant or say the police officer have suffered with mental illness, you have to bring that also in the pre-trial discussion to say, well, let's say the defendant is insane. Let's say the defendant committed murder and they're saying that, oh, this defendant suffered with bipolar and schizophrenic and often thought, hearing voices in their head. Those issues must be raised. And also any relief and sanctions for failure to comply by the prosecutor. So those are stages. Those are where continuance and pretrial conference is about, and pretrial discovery. Now, let's say right before trial, the prosecutor then decides, you know what, I don't really have a case. Then the prosecutor can file what is called nolle prosequi. And what it is, it's a motion with an affidavit from the prosecutor why he or she is filing a dismissal under nolle prosequi. If you guys, any one of you, please go ahead, look up nolle, which is NOLLE, and prosequi, PROSEQUI, nolle prosequi. So NOLLE and then space PROSEQUI, and tell me what you think that means.
That sounds like no prosecution or something like that.
Yeah, it is, but can you find something?
Nolle, spell it again, Pauline. Nolle what?
N, it's N as in Nancy, OLLE.
LLE, nolle.
Yeah, space PRO.
Prosequi.
SE, yeah, prosequi.
Is it no?
It's a formal notice of abandonment
Yes.
by a plaintiff.
Okay.
It's abandonment by a plaintiff or
By the
prosecutor of
yes.
all or part of a suit or action.
Yes. So a lot of times when the prosecutor realizes, you know what, I don't have a case, they can put in an affidavit and a motion saying they're asking the judge to throw out the charges.
Oh, a formal notice of abandonment. Or they might abandon it.
Yes.
No, they're not gonna
Meaning they don't have a
create
case.
the case. They're not gonna create the case. Okay. I represent the case.
Yes.
Lack of evidence.
So right before, and sis, this is very important for you to know because you are playing the role of the prosecutor. Okay? So just pay attention to what you're hearing because this is directly related to you. So then there's the prosecutor summons. So the prosecutor may have her witnesses. You're listening, sis? So the prosecutor usually sends the summons out to the witness along with payment to reimburse them for travel. So basically it's a summons out to your witness that they must appear in court. What happens if your witness failed to appear in court? What can you do?
You have to dismiss the case because there's no witness, right? No?
No, but you can, yes, but then you can also file a warrant out for your witness arrest. You can file with the court for a arrest warrant because it's mandatory that when you summons your witness and they don't appear, usually you can file an arrest warrant against them.
Really?
Yes, unfortunately. Yes, yes.
Whenever they say they summons you to appear, based on what I've learned, it's not necessarily you going to the court. You can appear based on sending your record and all of your documentation about your case.
Yeah, but for this purpose, they usually require your witness to appear in court.
Oh, your witness. Okay, I thought
it's your witness. This is your witness. No, this is your witness.
Oh, okay.
Witness.
Your witness can't come in and just drop off document and leave. It has to come in through the witness. Otherwise, it's not coming in.
Okay.
Yeah. So then it says, are you guys aware that a defendant is not required to testify, but is required to be present? They're not required to give testimony to incriminate themselves, or even if there's nothing to incriminate themselves, they're not required to give any form of testimony. Do you know that?
Suppose,
Everyone?
Yeah.
suppose you decide to keep quiet throughout your trial when them a question you, and you decide that you're gonna be mum and you don't use a lawyer. Can they still sentence you?
They usually can't because they have to make sure, and that's what somebody tried. You said, if you don't say nothing and keep telling them you don't understand, they can't prosecute you when you tell them say you don't understand.
Right.
Okay. Right. See, I have something here, court notice. When you get a court notice, you declining to appear. An
Mhm.
administrative court is a dispute resolution service for consenting parties.
That's all like a civil
A
situation.
summon is an invitation summoning or calling you to accept their dispute resolution service
That is not
in
a, that's
Admiralty
not a,
Maritime jurisdiction. So of
I don't know
course
why
you
them
have the
call it
right to decline.
invitation.
Yeah,
That's
so
not an invitation if they can put a arrest warrant out for
no,
you
they
to
might tell you
don't come.
actually what it is, but what they do is beyond
But
what thing
invite.
it actually is. Yeah. So of course you have the right to decline their offer of contract. Since
Mhm. Your phone is chipping in and out.
jurisdiction is attached to the artificial legal person, or it is. Since jurisdiction is attached to the artificial legal person name, not the living man or woman. So this is like what people in the private can do. These are actions that people in the private can do. So
Yeah.
go ahead, Pauline, not to interrupt.
Okay, no, that's fine. That's fine. So now, the defendant is entitled to a trial by a jury, unless it's waived. Then you can opt for a jury trial. Okay. So the defendant is entitled to a jury of their peers. Does any of you know what a jury of your peers are?
Jury of your peers is like your own kind of people.
Yes.
Your own kind, right?
Exactly. Yes. That's a jury of your peers.
As
And
opposed
normally,
to what? Trial by
normally
jury?
that's never the case, because me black and me not see why white people is determined saying they're my peers. They're not my peers.
Exactly.
So
but isn't that your right though to make that request?
Yeah, but it's never really always that way, especially in our state. You always find that the juries comprise mostly of white folks and barely anyone that looks like you. And what they do, and that comes to the next question, what they normally do is doing the
Pauline, trial by your peers versus trial by jury, right?
Mm-hmm.
Okay.
But what I'm saying to you is it's usually never a trial by your peers, which is the jury. Yeah. They're not your peers half the time. These people look nothing like you. These people don't even share your household income. They're probably richer than you or whatever. It's never usually a jury of, some of them old and you young. That's not a jury of your peers. A jury of peers is usually, for me, a jury of your peers is somebody that resembles you, the way your age, your race, exactly. So a lot of times why you don't see that is because in jury trials, the prosecutor use preemptory challenge. Do any of you know what is a preemptory challenge? Look it up.
Preempt mean that is
before
something.
Huh?
Preempt mean you anticipate something.
Okay, somebody look up preemptory challenge. That's
let me look for that.
Challenge them before they present the thing.
Go on, look it up first, Willie. It's preemptory and the word challenge.
Yeah,
it's just that they prepare themselves prior to the actual thing, preemptory trial.
A pre like meeting kind of where they discuss.
Okay, a preemptory trial hearing date.
Challenge.
Oh, challenge. Oh, challenge.
Trial.
Oh, challenge. Let me put that.
Yeah.
Okay. Challenge. Preemptory challenge. In American and Australian law, the right of preemptory challenge is a right in jury selection for the attorneys to reject a certain number of potential jurors without stating a reason.
Yes. And that's how you end up when a prosecutor, especially if it's a white prosecutor, they like to challenge a lot of the blacks and Hispanic without a reason. And usually it's because of bias and prejudice. Or if it's the opposing side, like the defendant, they might find that the jury is biased or prejudiced against their client. So they are entitled to a certain amount of preemptory challenge. It could be 5 or 6, and they challenge them. But once you use up all your challenges, too bad, the rest of the juries are coming in. Right?
Oh, okay.
Yeah. So it's basically when either party can challenge a jury because you think that they're racist, biased, prejudiced. Some juries will tell you that I'm going to be biased, and then they just say, you're excused. You understand? So anyways, next thing is, and this is now going towards the lawyers in this matter. Objections to matters and stipulations. So basically, now you're at trial, right? Let's say now you're at trial. And I'm going to tell you that second half of that. So we're going to go over objections that are later on today, not too far from now. And then you can make stipulations to the judge. Let's say you want to stipulate. There was a situation where both sides were stipulating to a breathalyzer test result because they couldn't find a chemist to come in and testify. Now, Clement, that's very important to your side. In the actual true story, there was a stipulation that occurred in the court between the prosecutor and the defense attorney. And the rule of law is you cannot make a stipulation without informing your client, which is the defendant. The attorney for the defendant went and stipulated to a breathalyzer test result without the defendant ever even knowing what the breathalyzer result was. And his attorney should have objected to that stipulation by the prosecutor, and he did not, and agreed that the breathalyzer, although it was a possible number, you should never stipulate to something that could possibly even incriminate your client. Right, Clement? You understand that, right? So stipulations is basically agreements between the parties. And usually you can call your own expert witness in. So let's say, for example, Clement calls his expert witness who can testify like, how far of a distance would this, if this police really see this drag racing going on at 127 miles per hour on a dark road, he can call an expert witness in and say, what was the visibility? What would have been the visibility at night where there's no lights on this road for 2 vehicles, or call a mechanic in to come and testify, or a car manufacturer? Can an old 2003 vehicle SUV drive over 127 miles an hour without tipping over on a bridge that looks like the letter S? A single lane bridge. Can 2 cars go over a single lane bridge shaping like the letter S? You see what I'm saying, Clement? These are things you should consider, that this trooper is saying he saw your client and he's on the roadway passing him going 127 miles an hour and going down the Marsh Road and going over the bridge, GE bridge, that shapes like the letter S in a single lane. Those are things to challenge in situations when you're dealing with calling an expert witness or even your own witness to testify, and also bringing in pictures, Clement. Then the case starts, and this is now, you understand.
So hold on, Pauline, sorry to intervene, but I just want to get the principle behind it. So what you're essentially saying is that whatever the claim is, you need to pick it apart and look at the practicality of it, how practical it is, or the reality. Okay. Yes. By picking it apart. Okay.
And if you want to have your expert witness call extra witness in, and all that, but you have to, you as a prosecutor has to tell Clement who you're calling as the witness. You have to. And usually your witnesses is the 2 police. Right? Your witnesses who observe or saw or observe anything or saw anything. Those are witnesses, not people when I see nothing, you don't call them in as witness. They're not witness to anything. And your evidence is one thing I'm going to tell you again in this session, how you enter evidence. So Clement and Sis, Shernet, you have to do an opening statement. Do you guys know what an opening statement is? You should know.
Yeah. Introductory thing, statement
so
as
make
to
sure
what the case is about.
Yes. So you got to inform me. You have to inform, and mind you, I'm only going to give you guys 10 to 15 minutes, no more than 15 minutes to do an opening statement, what your case is about. Right? And you must state it like this. May I please the court? Your Honor, may I approach the court? The judge says, go ahead. This case is about the defendant, whether you want to point at him, who has committed a serious crime. The defendant was on the roadway driving recklessly, and the evidence will show and state what the evidence will show. You will hear from 2 police officers who observed the defendant that night, who was a belligerent drunk, right? And then let's say now, this is Clement's opening statement. You will hear from my client that this trooper lied on him and made up evidence against him. And you will hear and know, and the evidence will show. The evidence will show the officer never clocked my client going over 127 miles. The evidence will show the officer don't have somebody directly who was there to observe my client doing any of the acts he claimed. In fact, my client had several witnesses who were in the vehicle with him who can attest that the statements made by the trooper is a lie and is unbelievable. You see what I'm saying, Clement?
Yeah.
Hello? So then you're gonna go.
Yeah.
Huh?
Yeah, he acknowledged you, Pauline.
Oh, okay.
Did. Yeah.
So then you talk about your argument, which I will go over that. That's the rule of evidence. And then jury instructions. So you guys need to give me an opening statement, a closing statement, and your jury instructions. You can go and Google what jury instructions are. Whatever instructions you want me to give the jury to prove, especially you, sis, to prove your claim. Because the defendant don't have nothing to prove but to show that he's innocent of what you're alleging. So you now have to come, you can Google how to write a jury instructions, and all here is basically whatever the charges are, you state that this is the element. If it's drag racing, you say the defendant was going over 127 miles, and then you give the definition of a drag racing. You can always look it up, sis.
So does it come in the sequence, opening statement, closing statement, and then jury instruction, or what sequence?
Yes, so it's usually opening statement. Any motions that you're filing, which I already went over what a motion is, right? And then your closing statement and your jury instructions. That's what Clement and you need to do. I need you guys to focus on your opening statement, what your closing statement is, and usually closing statement, I will allow you to do it in the end after the evidence is produced, because usually you don't know what your closing statement is until after the case has been tried. Right? And you can call.
So
I don't care if you have somebody coming in as your expert witness, but that expert,
addressing the jury would be a last thing to do.
Yeah, addressing the jury.
To address the jury would be the last thing to do, because you want to leave an impression on the jury.
Yes, exactly. So jury instructions is basically what you want me to read to the jury about the charges, sis.
Okay.
And then you guys know what closing statements are, right? And usually, as I said, closing statements occur after you produce your evidence or whatever you have to prove your case, okay? And then you have now the verdict. Do any of you know what a verdict is? You should know.
The judgment, right?
No, the judgment is what the judge writes. The verdict is coming from the jury. Verdict is how do you have the foreperson stand up and say, now how do you find the defendant? And the foreperson stands up, which is the leader that they pick, and say, we find the defendant not guilty or guilty. How do you find the defendant on count one? So sis, you have to have your charges presented as part of your jury instructions. Count one, let's say intimidation. Count two, illegally drag racing. Count three, driving under the influence. So basically, when the jury stands up, you say, how do you plead? How do you find the defendant? And the jury will say, on count one, I find the defendant not guilty. On count two, I find the defendant guilty. Blah, 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 blah.
Oh.
You understand?
So you have the classification. So the difference is a jury does not determine judgment. The verdict is determined by the jury, and what the judge does, they write the judgment and say, because the jury found you guilty, this court has now confirmed by judgment that you are. Mm.
That's how it works. The judgment always comes from the judge. Judge. Not you can't have a judgment from a jury.
Okay, I see your point. What it
is that the judge confirmed the jury verdict and write it as a judgment on this day. So let's say, for instance, if it's a civil case, right? And the jury came up with a judgment that, the person was injured, I'm going to award them $10,000. The judge then takes that $10,000 that was awarded to the injured party and then has to add the interest and do a final judgment and say, with the $10,000 from the jury plus interest, the total amount of your judgment reimbursement is, say, $13,000. So let's say there's $3,000 interest. You understand what I'm saying?
Mm-hmm.
And then you guys understand that if a party is not happy with the verdict, either party can appeal.
Mm-hmm.
Right?
Mm-hmm.
So basically, or there is a disposition. A disposition is, let's say the party is found, all the charges on count 1, 2, 3, or whatever, how many counts you have against the defendants is. Let's say the party has been found not guilty on all 5. Then the court does what is called a disposition, which is if you guys can tell me what a disposition is, that would be great. Is it this? Yeah. If you guys can tell me what a disposition is, it would be great.
From layman term is out of place.
Huh?
Out of place. From layman term.
Mm-hmm.
A disposition is when you're out of place.
Clement?
Really?
Yeah, man.
Put some cotton in your ears.
You're doing it again.
Put some cotton in your ears.
Clement, Willie, too sensitive. Cause you know about
I'm recording it and it's
we're recording. But Willie, I have the record for people to I'm gonna put it in the group chat.
Sorry, I didn't know you were recording. Willie. So you guys should know that every person, if you have a judgment or a final judgment and you don't agree with it, you can appeal it. Right?
What is it? What is it? Displacement?
I said disposition.
Oh, disposition.
What position they stand?
I don't think it's what you said it was, sis. I was trying to understand where you're coming from, but I don't think it's the way out.
Disposition.
What it means, it's
spelled, person in there.
I think you said it to disagree, right?
Yeah. No, that's not what a disposition
let me read it. Disposition, a person inherent qualities of mind and character. Your sunny disposition has a way of rubbing off on those around you.
Okay, let me
the way in which something is placed or arranged, especially in relation to other things. The plan is not.
Let me spell the disposition you're reading.
DISPOSITION.
DISPOSTION. Well, in legal terms, disposition is just to close the case out.
Oh, this saying, oh, see the law version here. The action of distributing or transferring property or money to someone, in
Or
particular by
closing the case
bequest.
out.
This
Or
is
to
a
close.
tax that affects the disposition of assets on death.
Yes,
Okay, so
it's to resolve or to close the case out. That's the easy way into the
okay.
criminal aspect. It's to close out or to disregard the case because it's been resolved and everything is closed. Basically, that's what it is. The ending of it,
Oh,
right?
okay.
So now the rest of this chat is going to now be how one will practice law in when you present in evidence and everything to the jury. So one of the things I want to talk about, and it would be nice that you guys even look at what the rules of evidence is, especially hearsay. I want to ask you guys, what is a hearsay?
It's something information from a third party, right?
Yes. Well, if anybody wants to go and look it up and give me the legal definition, you are absolutely correct.
False information.
What did you say?
I think it's false information from a third party.
Not necessarily.
No, it's not false.
It's
Not necessarily false.
basically secondhand information.
Yes, it's secondhand information doesn't necessarily mean it's false.
False, yeah.
So,
Secondhand information.
in law
Something
school,
said, something is said, but it was not said in the presence of the accused.
okay. So let me give you what was always the definition taught to me. So hearsay is an out of court statement. Out of court, meaning that if it wasn't stated in court in front of a judge on a stand under oath or whatever, it's hearsay.
It's not.
If it was a prior statement made on a stand before a judge, it's not considered hearsay, right? So it's an out of court statement offered to prove the truth of whatever statement was asserted and is inadmissible. So what that means is, again, we can go piece by piece with what I just read. It's an out of court statement. I'm sure you guys know what that means. A statement that was not made in court. It's called,
It's a gossip, another.
Basically, that's how you look at it. It's like a gossip, and there's nothing that you can prove to bring it in to try to say that it's true. Because if the person who said it is not there in court to come in and say it, it's considered hearsay. Because anybody can say, well, John Smo tell me this and Lisa tell me this, and it could be all a lie. You understand?
Mm-hmm.
So again, I'm going to put it piece by piece. So an hearsay is an out of court statement offered. Offered means to be presented by a person, right?
Mm-hmm.
To prove the truth. So let's say you want to prove, let's use Clement's witness. Ricardo was seen drag racing going down Fifth Avenue. He calls a state trooper friend who wasn't there to come and testify that he saw also that that officer, whoever the arresting officer is, which would be Clement, not Clement, but Willie, that Willie told him that he saw, or he could say, John Doe told me what Willie told him that he saw this and that. You see, that's hearsay because it's not coming from the person's mouth who actually said it. It's coming from parties who were not a witness to it. Do you guys understand?
Mm-hmm.
So, and it's always, usually a hearsay is a statement that is coming in to prove that what was said is true. And they do not, and it's inadmissible. Inadmissible means it's not allowed to come in. But, do you hear the word but? But there is exceptions. And the exceptions to hearsay is, and I need you guys' assistance because I need you guys to look this up. And it's usually for you, sis, and for Clement. What is an excited utterance? That's one of the exceptions when a hearsay can come in. It's under excited utterance. You can look it up. It's EXCITED utterance. And tell me what it means for excited utterance. And I'll give you an example of such. And if any of you want to chime in, that's fine. What is an excited utterance?
Excited utterance.
Yep, that's EX. Huh?
It's like an utterance of like unexpected utterance.
Say that again. A what?
Like an unexpected utterance.
Can you give me an example?
It depends on the scenario or situation, I guess.
Okay, then let's use it for this fact pattern.
Is it something that is not well thought through and impulsive?
Yeah, it's impulsive.
Yes. So basically, excited utterance. I'll give you an example. When I got hit by the tractor trailer, I jumped out of my car and a witness saw me jumping up and down screaming, I just got hit. That's excited utterance. And so that witness can say, I saw Pauline screaming. She just got slammed by a tractor trailer and she's jumping up and down screaming. That's excited utterance. Oh, I just got hit. Or let's say in the case in chief, some lying witness come and say, oh, I saw the car zoom by me. It must have been going over 127 miles an hour. Oh my gosh, did you see that car go so fast? That's an excited utterance.
That's what I'm saying. Something that is not thought through. It's like an impulsive thing.
So they say when people are under excited utterance, they're more likely it's a truthful situation. And a witness who even observed that can say what they saw, what that witness said during the excitement. If there was a shooting, oh my gosh, did you see when Billy shooted Lisa? Excited utterance, your adrenaline is going, right?
Impulsive.
Yes, so that's an exception when it can come in. What about present sense impression? That's another exception. Presence sense impression. That's PRESENCE impression. Presence, that's PRESENCE.
Present sense
impression.
Presence.
Who can tell me what is a present sense impression?
Present sense impression. Presence sense impression. Is it something that you like an intuition or
Not really.
an idea of someone appearance or something?
It says here that a present sense impression in the law of evidence is a statement made by a person that conveys his or her sense of the state of an event or the condition of something.
So what that means is it's almost similar to excited utterance, where they said, I was standing there and I saw this. It's like they're telling you as if they're still there. They're on the witness stand telling you what they saw at that moment and they're reliving it. You get what I'm saying? Like, it's similar to excited utterance, but excited utterance have more like, oh my gosh, it's animated. But present sense impression don't have the animation. And what it is the person is telling you how they felt at that time.
Okay.
Does that make sense?
So are you saying that the person will show like real emotion as if they're actually going through the situation, reliving the situation again?
Yes.
Okay.
Present sense impression. If you guys want to chime in and come with something.
Okay. Yeah. I see that. Yeah.
You know what I'm saying? It's their state of mind at the time.
Yeah. It's like they're reliving it, like they can't tell the difference between whether it's happening now or it was then. That kind of a thing. Like
and so
they could sense they sense the real emotion, all the senses, everything start to activate, reactivate.
And you have to understand that it's a different person who is telling you what they observe about that person at the time that the event occurred. She appeared to be in a trance. She appeared to be cold, freezing, gripping her hands. That person who is the witness to it is telling you as if they were still there at the event, observing the individual. Remember, hearsay, it's not their life experience, it's someone else's. And they're telling you that this is how they saw. I saw Shernet standing there shivering. So the weather must have been cold at the time. You know what I'm saying? So they're reliving what they saw at the time of a third party who is not in court. Right? So that's present. And it's almost similar to excited utterance, except that excited utterance of, oh my God, so she was screaming and acting radical. That's the difference. You know what I'm saying?
Pauline, so what you're saying, this will occur when somebody gone through an experience or maybe previously went through an experience, but then you as a witness came on the scene and see the person handling the trauma, going through it.
Yes.
Processing the experience, but you didn't actually see the actual experience. You just
you have to have. That's what a witness is. You have to have. You can't be some random person coming saying, if you didn't see the person experience it, you cannot come.
No. I'm not talking about that. Say the person went through a traumatic situation.
Yeah.
Right? And then it's over. But then it's not there. The situation, you weren't on the scene when it actually happened, but you came on the scene when the person was going through the processing the situation that they just went through, right?
Yeah, and you're telling it like it's in the present. You take the stand and you said she appeared to be ice cold and she was shivering. Her head was held down low. And you're given this experience of a person who's traumatized, but the person is not there to tell you their own trauma. Somebody else is telling you what they perceive at that time about that person's then existing state of being.
Okay.
Right? That now comes to the existing state of mind, which is sometimes called the then existing state of mind. Again, some of these are almost similar. And what a then existing state of mind is, how the person existing at the time. Did they act psychotic in their mind? Oh, I saw a ghost. You see what I'm saying? Oh, that person then takes a stand and says, Lisa said she saw a ghost. That's in her head. She's telling you what that person then existing state of mind was. Or a person who's sprawled out on the floor, right? And it's crying emotionally. It's various ways how you can use a person's action and use it under excited utterance, then present sense impression, or then existing state of mind. The state of mind is talking about the person's state of mind. Were they calm? Were they crazy? Or were they just in a trance? You can tell when a person is calm, acting erratic. That's their then existing state of mind. Right?
But it is similar to the present sense of impression.
Yes, it is. But you're saying what their state of mind is.
Was at the time.
Yes. Did the person appear to be crazy? Did the person appear to be uninjured? Did the person appear to be, animated? Mind you, you're not talking about the excited utterance. You're talking about the person's state of being, their mind. How did they appear? Did they look crazy? It's no. Oh, they appear
or traumatized.
Yes. And so it's called then existing state of mind. So you're thinking of their state of mind.
Yeah. Also, the existing state of mind. Okay.
Yes. And then there is the medical diagnosis and treatment one. A person can come in and say, I took Joan to the doctor to have a surgery done on the tour that she got from the accident. Or I brought Johnny outside and brought when Johnny was injured and took him to the doctor office to be checked out for his ankle. That's a treatment statement. So let's say it's a statement where a person is saying, let's say in Ricardo case, Ricardo now wants to go and sue the police for all the mental distress them cause him. And let's say he had a friend that drove him to his doctor appointment for the mental distress to show that he's under severe distress. His friend can come in even without Ricardo there and says, I took him to the doctor office because he had some medical issue with his shoulder. These are treatment and medical statements. You know what I'm saying? Or a doctor can come in and give that statement as well, right? And then there is the recorded recollection. Let's say your witness, Sis or Clement, took the stand and don't even remember some of the detail of what happened because time has lapsed and their brain just started deteriorating as to the facts. You want your client to come out and say, for instance, let's do the police. Let's say Willie. The police now remember if at 2:15 or 8 o'clock, and when you ask him, on this day, what time did you said you saw this drag racing? And Willie said, well, I don't recall. Then the prosecutor can say, Your Honor, I would like to refresh Willie's prior statement that he gave, that because he doesn't recall. And then the judge may say, okay, I will approve. Clement can jump up and object and say, Your Honor, I object. And the judge is going to say, why you object to the refreshing of his memory by a document that he previously wrote? So, Your Honor, if he doesn't recall, then that goes to show that this incident, he made it up and that he cannot remember his truth from his lies because he can't even remember the facts. And let's say the judge says, your objection is overruled, Clement. And then you ask your client, do you recall when you stated that this incident occurred at 2:15? I'm going to show you this document. Do you recall writing that statement? Oh, yes, it was at 2:15. That's when you're allowed to refresh a person's memory. And
overrule. Sorry, before you go on. When the judge say overrule, what does that mean? That what?
Overrule means if the party objected and don't like the other party to bring the evidence in, the judge can overrule it and allow it in. When it's sustained, that means that the judge is not allowing it. So the overrule means whatever the party wanted to bring forth and the opponent object, the judge says your objection is overruled, I'm allowing it. Now, if the judge says it's sustained, that means you cannot bring it, you cannot talk about it.
Sustained, okay.
Yeah. So then, as I said, if you hear Clement, vice versa, you Shernet, you hear your opponent saying something that could incriminate your client and you think it's irrelevant and it's off topic, what you must do is objection to the court and says, usually a jump up and say, objection, Your Honor, or judge, or whatever you want to say. This is hearsay. Then the judge will decide whether to sustain it as
my honor, never your honor. My honor, not your honor.
My honor. Use whatever how you want to say it, Willie. However, you, Clement, Shernet, however you want to address the person in the black robe, or you call them black robe or whatever, and do what you want to do.
There's
but
nothing honorable about these people. The whole of them
you know
have to collect money.
So again, I'm just teaching you guys now how to do the procedure part when you're presenting the case, because I don't want you coming into court presenting a lousy case, because I'm going to make you go back to the drawing board. So anyway, when you hear me say, if Clement object or you object to something Clement says and you think it's not relevant or it's hearsay, you object under the hearsay and says it's an out of court statement, Your Honor, and it doesn't fall under any of these exception, Your Honor. Therefore, I'm asking, or My Honor, therefore I'm asking you to sustain my to overrule the defendant's objection, or vice versa. So again, you understand that when it's sustained, that means your objection is allowed. And if it's overruled, it means it's not allowed. Now that comes to the last part of
No, overrule meaning it's allowed. Sustain meaning it's not allowed.
Sustain is I'm sorry. Overrule means it's allowed. Sorry.
It's
Sustain
allowed,
means
yeah.
it's allowed. Sorry,
Right.
yeah.
Okay.
So overrule means that the judge is going to allow it to come in. While sustaining it, the judge says it's not coming in. Is before I wrap up and then give a review of what I want Clement and Shernet to do, is how to enter tangible evidence. So let's say you want to enter the Willie police statement report into evidence. Usually you say, My Honor, as according to Willie, may I approach the witness? And the judge will say, under what circumstances? Or maybe the judge will say, go ahead. And then you say you ask the witness, do you remember when you wrote up a report on May 22nd, 2017? And Willie will say yes. And I'm going to show you a document. And Willie will say, okay, yes. And you say, Your Honor, may I approach the witness to show him the document? The judge My Honor will say yes. You go over to your witness and says, look at this document and tell me if it looks familiar. And Willie looking at it and he says, yes. She says, then Shernet says, does this document look familiar? And once you say yes, she's going to ask you, and what can you tell me? What is this document? Oh, this is my initial police report. And is this an accurate depiction of the police report that you wrote on May 22nd, whatever? And Willie will look on it. Yeah, it looks accurate. And is this your signature on the document? Yes. And so this is your police report that you actually authored this day, signed right there, and it's accurate and depicted at the time when you wrote it. Yes. Then you turn to My Honor and says, My Honor, may I enter this document into evidence as Exhibit 1? Do you see how that works? Now, Clement, again, you don't really have to prove nothing, because, again, it's Shernet's duty to prove her case. In your situation, you might want to present something. Let's say it was the video that they remember Clement in the fact pattern that your client has a witness who video recorded him. Right, Clement?
Video recording him walking straight with his hand in front. I need that video
and let's say
to prove.
And let's say you call that witness to the stand and you have the video and you turn to the witness and you say, first you say, My Honor, may I approach the witness? Yes. I have a video here and it's dated blah, 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 whatever. Do you recall doing a video on that day? Yes. Now I'm going to show you the video and say you have this video recording on the phone that the person took it on. Is this the phone that you took the video on, or is this an accurate depiction of the video that you took on this day? Your witness says yes. And then you say, and does that depict the exact time and place and location and the person that's in the video? Yes. And was it you that took this video? Yes. And it's an accurate depiction of the video that you took that day. And it hasn't been altered or anything. No. Okay. Your Honor, may I enter this video as Exhibit 2? into evidence. You see how you do this, Clement?
Yeah.
So that's how you
But for
enter
me, it would be
evidence.
exhibit one if it's the first one.
Huh?
If I'm entering the first evidence, it would be exhibit one for me, not exhibit two.
No, I'm
That
just
one,
giving
two.
you an example. Yes. For you, yes. But do you
Okay.
realize that all the evidence, they go in order. All the evidence are going to be combined. So whether the prosecutor who's going to go
Okay.
first, obviously going to have exhibit 1, 2, and 3, and 4, whatever her charges or whatever the heck she's going to try to enter, or whatever videos, or whatever she has. And then yours now go after the last number. So let's say it's 3 for the 3 evidence for the prosecutor, then yours go number 4, 5, 6, and so forth. That's how it works. And it's the same way in the civil procedure. Okay, so you understand how to enter evidence, attorney. Huh?
I always come last after the prosecutor. I am the train wrecker and the disorderly.
Mm-hmm.
I come to tear up the prosecutor's case.
Tony, you want to be the prosecutor? I'm running from Clement. Clement's so dangerous. Tony,
Clement, you know, I
you
told
want to
my
be the
sister,
contender?
Clement, I told my sister, so you're going to rip her up.
Yeah.
Tony, where are you? You want to be the prosecutor? Is he there?
Oh, Tony.
Tony.
I'm here.
Tony, I think you should be the prosecutor.
But I don't know because I'm just basically logging in. So.
But Tony, you're supposed to be one of the jurors, aren't you?
Well, I'm supposed to be somebody in the car, like one of the witnesses or something. But
because
I wasn't sure, I wasn't sure which one. So I just said I'm the juror.
You can play any of the witness. You can play any, because as long as he gets one witness to come in, that's good, and the witness who record him.
Well, I'm gonna have to prepare for this case, because I am telling you, I'm not even. What should I say now? My mind is like.
Well, I hope that the witnesses, whoever is playing the role as the witnesses, the police officers, and juries not supposed to even be listening to any of this, because they're supposed to get it fresh and listen to the evidence from fresh. But that's fine, because since we're doing a mock trial, we're acting too. That they weren't privy to anything. But for the purpose of all the witnesses on here, make sure you know your part and your role and what the evidence, and you cannot go outside the evidence, because that's all that was presented. However, for the prosecutor and the attorney, their role is to know the rules of evidence, how to get their evidence in, when to object, and don't sit down. And sis, don't let Clement sit on there and bring in all kind of sitting, and you don't jump up and say, objection, my honor.
Okay. So listen, what we need to do, the know the rule of evidence. Let me write those, because principle, I have to get principles into know the rules of evidence and what?
You have to, what I want you to present for next session is the opening statements. We have to have an opening statement. And any motion, if you want to see a sample of what a motion is, if there's something you're trying to exclude, either party who's trying to exclude anything you think might be bad for your case, you're more than welcome to file whatever it is. Just tell me what your motion is about. A motion is asking the court for to do something, to make an action onto a matter. So if Clement thinks that there is something that's incriminating against his client, he can file a motion to suppress. Let's say it's the cell phone that they search. You can file a motion to exclude it if it's not one of...
What? I have lots of motion to exclude.
Sorry, don't give Clement any ideas.
It's called
Hey, Sherman.
Yes.
Number one, that case should never go to trial. Because he was not ready his Miranda rights. And anything comes in after that. It should never go to trial. It should have kicked out.
Yeah.
Wow, Clement is ready to eat your
May I
life.
tell you, Pauline,
Huh?
she's like another prosecutor. This a prosecutor, you're weak.
I'm sorry.
No, no,
Sorry for the
Did
prosecutor.
you know that?
it's
Did you know that lawyers do take cases when they know it's a losing case? It's just really still trying to 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 still try to deal with it, and because even when I
You
went to
need a
law
cookish
school,
person to be the prosecutor.
no, because listen to this. When I first went to law school, they gave us an exam to see if you are equipped to come to their school. And they give you a fact pattern, right?
Uh-huh.
And they make you play defense and the opponent. Like you playing
Okay.
the plaintiff and defendant. They first ask you, what would you do as a plaintiff to argue this case? Give you the same fact pattern and ask you what you would do if you are a defendant to fight this case. So it's really you people, you might come across a bad situation where you feel like, oh, maybe I did run through the red light, and you have to find a reason why you justifying that you didn't go through the red light, even though say you go through the red light. You get what I'm saying? You can say, officer, the light was turning yellow before as I proceeded and turned red on me, and the light was shining. There was sunlight coming on, and you have to learn to play the game with these people, because these
Yeah.
people play games with you. They're mafias too.
Yeah.
You think they're innocent people out there doing things? They're criminals themselves, as Willie says.
Yeah. The one who is more the
Yeah,
most
yeah,
crafty
you have to know to
ones.
tell good lies.
Yeah, that makes the ones who are more crafty.
Just like
Yes.
when police someone give me a ticket, me tell lie pan her in a court.
Yeah.
What
But
was the lie?
oh, she was I was going say east on a west on a street, and she came up north on a different street. Look
Mm-hmm.
around, saw me in a BMW, make a U-turn in the street, come around and pull me over, and told me that my plates were hanging. I went to check my license plate. Yes, indeed, it was hanging. She asked me for my insurance and thing, and I didn't have my insurance on me. So she gave me a ticket. So I remember when I used to work at the rental car company, they only put a photocopy of insurance and the ownership in the cars. You know? Anyway, she gave me a ticket and said that, oh, the reason why she pulled me over because my plate was hanging, like I said, and she didn't want to cost me any money to replace it. Some just got cool until the just the piece said, listen, I gave her a copy of my a photocopy of my insurance and thing, because I didn't want to have the trouble with the original. And she pulled me over and stated that she want to save me money because of my hanging plate. She didn't want to lose a plate. So I said to the JP, I said, if she was trying to save me money, why would she issue me a ticket that's gonna cost me money? You just knock your hammer and say you're free to go.
So she wasn't there. She wasn't
Yeah,
in court.
she was stunned. I let her read her statement first. She want to refresh her memory. So refresh her memory. Let me just throw her a curveball. She could, because once she read her statement, she can't say nothing again.
Wow. That's good. You did a good job. Maybe you should
Yeah.
play the prosecutor.
Yeah, that's what I'm saying. Tony sound like him used to them kind of setting. Tony, come on, study the case and be the prosecutor.
Why? Why you afraid of Clement?
Yes, man. I'm not. What should I say though? I want to find an appropriate word.
Wait, you see,
I'm not
you
made.
create this program to teach people how to be strong. I hear you are chicken out.
Hey,
Oh Lord.
don't worry. You'll be surprised how well you perform when the time comes.
Okay, I'm going to. Yeah, I just need to learn the principle. I know you have. There are three things I need to focus on: opening statement, closing statement, and jury instruction. So I'm just gonna prepare myself for that.
Well, as I said, the two lawyers should know how to present the case, how to object, and so forth. And the witnesses should know what their speaking parts are. So when your prosecutor or your client, or I mean your attorney speaking to you, you know what to say. And as I said, I'm gonna need probably a few more jurors. And I have, as I said, two friends on here, Judith and a friend King, who are willing participants as jurors. So to hear the case, how you present it, and give their opinion. So you can add them,
Yeah, but
sis,
sometimes
to
you can
the
have a trial
jury
court
list, which
proceeding
is
and
Judith
it's
and
not a
King.
problem because
Judith and so
King,
Tony going to be what?
Khang. I
Oh,
thought you said Tony said he was one of the witnesses
Judith
in
and
the
King.
court.
all
Okay.
right,
Yeah.
so look here.
So
Remember
Tony is
them
one of the
time,
witness.
you know,
Okay, so I need to update that. What is on
just
there?
make him a pass out heavy, you know, and him just get pass out a little bit.
KHAN is Ken.
Him
Ken
not have nothing
Khan.
to pass out.
Her name is Khan. Pauline.
Khang. It's on there. It's on there.
Okay, HANG. Okay.
Yeah.
Yeah,
So
make
so
sure
that
them
mean I
put
could
so make
be
sure
one of the
everybody
witness
should
in the
ask
car and a
equally
juror, right?
questions. And if she
If you
continue
Yeah, you
want
can
to be,
play
that
to
would be
both
remember
roles.
nice.
those are what
But
we
do
Yeah,
you think you can be
because
extremely
unbiased?
advised
yeah,
because
the
when
person, the
she
ones in the cars,
hold
they
on a
don't have
while
much
ago, you
parts.
know
They
we
don't have
heard it
much to
though.
say in it.
No,
Listen
they
here, sir.
don't,
When she
because
said
it's
bubble
up
Yeah,
to
clot,
Clement
right?
what Clement
She
wants to
throw me a
ask them.
bottle and
Make
yeah.
him be one of the
You get
juror
she cover
to
the
come with
points
the
at which
verdict.
it's supposed to be at the seam, right? So she has
Pauline,
say, if
did you
the thing
say?
say,
make him be
give me a
part of
moment.
the
So me
juror
say,
to come up with the verdict.
you
Cause you know that the
Okay.
juror play a
because
yeah.
it move from
Yeah.
You know,
one
I do have
to
selective memory. I can also
right.
forget.
So
I
hold
forget
on
what
a
I said
second.
as
So
a
when me
witness.
ask her,
But
well,
guess
look,
what? That's
she
why
not give me
Clement
answer.
will
Me
have
say,
to do
I
a
ask you the
refresh
answer.
recollection. I
Can you
went
allow me
over that with him.
allow
That
me
if your
speak?
witness
When me
forgets
look, Shirley
something
take
and
out
you
all
want
my
to refresh
things
their memory, it's
put
called
it in
refresh
another matter. So me
recollection,
say, which one you
where
gonna
you're not
use?
supposed to read the
Right?
evidence to them, but
She
ask
take
them
out
if they
some and
remember
then
on
put it there.
certain day, if
That
they
means
wrote
she
this
only
on
take out
the
half of
statement
her
they gave and
whole
blah, blah,
memory.
blah.
Meaning something.
Also, it's like you're dragging their memory then, like remind
Yes,
them of
yes,
us
it's that,
an
and they,
incident that will drag their memory.
yeah, and it's
Okay.
also called refresh recollection.
Or refresh
And
recollection.
then
Mm-hmm.
the one person
Yeah.
say
Okay.
That is
push it
when you
all
want
the
to
way,
put
and then she
something
remember
in,
no, she should push it all the way.
Mm-hmm.
Too many people. No, that listen.
Okay,
like
That
you
listen
want
Clement.
to
to me.
question him on his
What
report,
you just said to me, Lisa?
then you're gonna
You said
refresh his
put it all the
memory,
way.
or you ask him if he wants to refresh his memory from
No,
his
me not say that.
notebook,
What you just said before,
and
Lisa.
then
You said
refresh his
refresh
memory.
is far enough.
All right, it's now 10 past
What you
10.
say?
This was a very good discussion.
Uh-huh.
It gives good insight of what goes
You
on
see?
into the court. I have recorded it and I will post the
Uh-huh.
record
Uh,
in jurisprudence so that we can
Uh-huh.
review
so when
what
is the
we went
actual?
through.
When will be the actual trial?
But
Not
me,
next week. Not
all
next
right,
week.
look here.
Oh,
All right,
well, it depends on
think about it. Think about
the
it. Come on,
preparation.
if you're giving him
Yeah, so the
Yeah.
preparation
75,
actually,
Yeah.
the
and
major role is from the
if you give him one
prosecutor
of the
and you,
strongest
Clement.
something in there,
Yeah.
and
Yeah.
you
So
want to
let's
So
cover
put
up
some
we
prep
gonna
certain
in.
pharmacists say
Once you are
do that
prepared,
that
if
is
you
very
need help or
aggravating and it can
needs
damage
me
him.
to,
She
to
said,
ask
don't go
certain
do
things, you can
enema, do
always
something gentle.
hit
Shirley,
me up
don't
on
go do enema,
jurisprudence, Clement.
right?
okay.
But I
So
believe I have
and the guy
given
was
enough.
saying,
If you
listen to me.
want me
The
to
guy
give you
says
a review
it's
of what
better
I
to
just said
forget
today,
about
because
the
I did write
enema
it up,
if you're
what
just
I was going to
dealing with
Yeah.
discuss.
just
I don't
believable.
mind
It's
giving it to
because it's
you.
only take out what is in the
If you
right
didn't
now.
make any
But
notes today,
if you feel like him
it's
coming
all
up
up to
all
No,
the
you.
way,
I make a few
you need to
notes.
just
Right. The
Okay.
understand the
most
enema and
important
use the
part was
Nylox or what it want name.
the
So that's
opening
why I tell her, I say,
statement. If I
tomorrow
want
Yes.
to
I would
put in
have
a
called you,
motion for
get the
dismissal,
Nylox or what
motion for this,
bother,
motion for
because the
that,
Canadian
Okay.
government
closing
have this now in
statement,
effect now.
Okay. Oh,
instruction
wow.
to
All
the
right. But
jury, and
see,
the
Shirley,
verdict.
we have pressure ourselves.
Okay.
Verdict
And
is for jury, not me.
we have to be
Yeah.
careful of not
Yeah.
experimenting with the
So
trial.
you're down pat, Clement. You got it all. Oh, I feel bad for my sister.
Still,
No. My your sister is a veteran, and I come there upset the apple cart.
really, not in
Some
court.
Me
I'm
just
not even
pray no
familiar with a
somebody
whole
give
lot
too
of
much
terms,
something
but
where
I'm
well,
Well,
somebody
it's
you
we
just
are in a
got
learning
something.
process.
Yeah.
Learning process. We fail to learn and learn to fail.
I'm gonna be excited to hear the opening statement though.
Well, I'm gonna
That's
surprise
the
you
one I
all.
want to hear the opening statement.
I'm gonna surprise you all. I'm coming well
I
prepared and
know.
armored.
And yeah. Well,
And anyone who wants to read, I think this is whining, who wrote in the chat the definitions.
Okay.
Mhm.
The other day, we'll go back
yeah.
and
Oh, and
But
one
we
other
might.
thing I forgot to tell you guys. If it's a statement by one of the parties in the court, it's not hearsay. That's another exception. If it's a statement, let's say, Clemens witness want to say what the police told her when she was the one who did the video recording, or any other witness in the vehicle, the statement is coming in against the officer because he is a witness or he is a party to the case. So therefore, it will come in against him. Once the person is the accuser in the case, you can bring anything that they said against them.
Okay.
So if he told the other vehicle that did the drag racing to leave the scene, the person who he told that to can come in and say, Officer such and such told me to leave the scene of the arrest.
Let me ask you a question because I didn't see it in the preparation there. Did Mr. Ricardo, when he was accused of being drunk, did they take him to a medical facility? Was his
No,
blood
they did not.
drawn? Did they know the contents of the percentage of blood in his
No, they did not.
alcohol? No, they didn't do nothing like that.
Nope,
Okay.
that's why it wasn't there.
Okay.
See, you're smart.
So how that thing end up in court? Because honestly, I honestly don't. How in real life? How well did the prosecutor perform? Because she has to. I don't see much grounds for the prosecutor to perform positively in this case. Pauline.
So what I can tell is that she was very crooked.
Oh, okay.
She started coming in the case talking about that she wants to add 2 years and 3 months later in the case that the defendant had drugs on his mouth. She tried to say he had crack cocaine on his mouth. And she was trying to add this 2 years and 3 months later.
Oh, so so does that justify the approach to not follow certain protocol?
Yes.
So she used that as justification?
Later on, by the way, I'll give you an update on the actual true case. Yesterday, the defendant who was found guilty of 5 of the 9 charges has a hearing December 8th at 2 p.m. with the judge who heard the case, because there was a motion filed for a new trial or to throw out the conviction. So there is a hearing coming up on December 8th regarding the unlawful conviction. And then for the federal case, where he's suing the officers and the prosecutor for what they did, there's a hearing on November 18th, I think at 11 p.m. I don't remember. I got to check it out. I have it in the email for him to appear to defend against the motion filed by the prosecutor, where she's saying her actions is privilege and that you can't sue a prosecutor.
Pauline.
Really?
Yes.
For you. So, are you aware that anyone can actually W4 these court cases to shut them down?
I'm not familiar with it, but I've heard about it.
Yeah. So everybody on the
Go ahead and enlighten me.
Who is that?
You have to give him my time.
so
Her name is
Who is that?
Camicia.
Who is that person with W4?
Camicia. So
Camicia?
yeah. So right now, a lot of people are W4ing all the cases because what they're doing, they're getting paid from the
Sestiki V Trust. Yeah.
I hate saying
I'm
that word.
sorry, what the what trust?
Sestiki V Trust.
Skeski EV.
This is where they get paid from. So
Can
one
you is this for Canada?
Canada and America.
And the US.
Okay.
Yeah,
Everywhere in the world.
in layman terms, your birth certificate is a bond, and that is the certificate
On all
trust.
of that.
Right.
Mm.
Yeah.
Is the
So
thing that I was wondering if she can type the name of the trust into the chat so I can have a proper spelling.
I just I think
Okay.
that's all. I just did. Sestiki.
Okay.
I said
Okay.
Sestuki. I think the TU.
QUE and
Trust.
VIE.
Sestiki V Trust.
Yeah.
And what is it? And go ahead and what is it that there?
So basically, every time any officer file any motion against anyone, they're actually creating a bond.
Yeah.
Yes, against your trust.
Yeah. So these bonds now, they're trying to collect money off of these people by creating these bonds from that trust account. And so when you W4 them, you're auditing that particular case, QSIP number. You're auditing each case. You get a W-9 from the courthouse. And if they refuse you, then you put that in your letter, your cover letter, and you let the Treasury know that they have denied this W-9 to you. So they're now going to go in and they're going to audit that particular case number. And once they audit it, they're going to shut it down because all of it is fraudulent.
So
And
you're saying,
my-
okay, let me make sure I get it clear.
Mhm.
You're saying by previous experience that wait a minute, which one is the proper spelling? I'm sorry.
The second one. I think it's the second one.
The chest, okay. And so you're saying when the officer files the complaint, because often we don't file motions. So when the officer files the complaint, in essence, they are creating a bond under the Chester
Exactly.
Trust,
That's
right?
common.
And
Yeah, that's
then,
common.
and then you said, what after that?
And then what happens is that when you W4 that, you fill out the W4, you fill out a W4 and a 1040 and a 1040V on them, and you write a cover letter stating your intention and what you want the Treasury to do with it. And you provide them the case number and also the you get an EIN number or a W-9 from the courthouse. And then when you get that,
the EIN?
Yeah.
EIN number. Oh, yeah, I know what that is. Yeah, I know what the EIN number is.
Yeah.
Identification number.
Yeah. And so basically what you do when you get all that information now, you provide that information on your W-4 and you send that off to the Treasury and they close the case down. Many people are getting out of jail like this because of that.
So isn't there a 1099 OID form included in the W-9?
No. Oh yeah, 1090. I think some people. There's different ways of doing it. There's 1098 and 1099 OID. That's another way. So there's more than one way to get it done. But yeah, with the W-4, it's very powerful, and this is how people are getting themselves cleared and cancel those cases. You can even W-4 your driver's license, any license and any certificates can get W-4.
What about your bank?
And you get back,
Yep.
you want them to recoup what they've taken from you. So now the Treasury goes in, audits them, and then whatever is remaining that's actually your funds, they return it back to you.
So you can do your bank so well?
Yeah, you do your bank account, you do your bank
for your
account.
mortgage.
Yeah, your
Bank,
You know they are robbers when it comes to mortgage.
your insurance too.
Anything, like almost even your high school certificate, like everything, and college, university certificate, you W4 that and you get money back. And because it's all fraud.
Commission Prudence?
Yes.
You and Prudence?
Yes, I am.
I'll be in touch with you. I'll be in touch with you.
She's supposed to.
Kamisha
is supposed to have a
doing that
meeting.
service. Yeah, she's actually because she did the course, she did a course,
I did the
and
course.
so she's
And
she's
you can also
perfecting
do
it and
identity.
everything like that, and she has the knowledge.
And,
All right.
you can do identity theft on them, because sometimes they do identity theft on your stuff, and you can and then you can get a pin and then shut down your SIN number, right? So, or your SS number. Yeah,
We have a lot of information that I need.
we don't have to subject ourselves to their tyranny and what they're doing, because it's all fraudulent.
I always thought they were running a fraudulent enterprise, but I didn't know. I know what a W4 is, and I certainly know what a W9 is.
Yeah,
but I usually only see it being used for tax reasons, for like when you file.
They make people think, yeah.
And I never seen it used on like cases like what you're saying. So that's why I said to enlighten me.
Yeah. Well, Patrick Merrill is teaching this stuff, and actually I've taken the course on it, and I've already sent in a couple of W4s on my credit report. So you print your credit report off and you send that off. You do W4 on it and you send that off to the Treasury and make them audit the credit agency, because even the credit agency is fraudulent.
Judith is asking for people to provide their phone number. I don't know.
Well, everybody is in jurisprudence. Kamisa,
maybe we can so
Judith, she can send her a message.
Judith will send you an invite to the group, and you can get information. You can email them or talk to them on WhatsApp through the jurisprudence group. That's how we talk with each other.
Talk to each other.
It's through jurisprudence, and you'll have a direct link to them.
Yeah, so I'll add you, Judith.
I'll send you the invite.
Yeah, so you can do that, Pauline.
Yeah.
Yeah.
Well,
so
it's
I just want to let you guys know that you don't have to go through what they're putting you guys through. There's another way out.
Well, you know something? God, these judges know about the W4 process.
And that's why they run out of court when certain people say certain things.
Yeah, you walk into the court and you say, listen, I'm fully aware. I'm fully aware of what's going on. Just ask them for the W9 and tell them, say, listen, I'm gonna slap your W4 on the desk and say, listen, I'm ready to file a W4 on you guys.
You don't let them know what you're doing. You just tell them, oh, you need it for accounting purposes.
So you need to ask them for what? What you ask them for?
The EIN number, their EIN number, the courthouse EIN number, or you ask them for the EIN or W9. The W9.
W9. Okay.
I mean, you don't have to ask them for the EIN number, because it's in public record. Because each court is a corporation.
Wrong information, right? Because sometimes what they do in the public, they put out fake stuff that is not real. So you don't want to trust what's in the public.
You know something.
Can I do a quick run through just to make sure I have it clear? Let's say it's a civil case, and you want to shut them down for the unlawful civil case, right?
Oh yeah. You just got me phone.
What you did, you said send a 1040 and a W4.
A 1040 and a 1040V and a W4. Okay,
1040D.
Not sign anything.
Wait. 1040D.
V as in Victor.
V. Okay. So you send a 1040V and a W4.
A 1040V and a 1040.
Okay. And the W4.
I can
meet with you on the one away and we can discuss it. or I can do like
Okay.
Right.
Yeah. So
You know
Alright,
something?
alright.
anybody who need help,
what I
just contact
yeah.
Tamisha.
Camise, yeah.
She's on the
What I
thing as Tammy Brown.
yeah.
So
What I
interested with it.
also
Tamisha,
Mm-hmm.
I'm gonna just send
Alright.
you my number
Okay.
on the chat.
Yeah.
Okay.
Yeah.
On this chat. I'm gonna just send it to you here right now.
yeah, and what I
Absolutely.
also learn to some of these people in these public offices,
Mm-hmm.
they have their own personal EIN number.
Yeah, that's right. And you can W4
So
them
you have to ask. So
individually.
you have to ask just for his EIN number, ask the prosecutor for his one, and
Mhm.
their lawyer for theirs.
Right.
Yeah, so Pauline, you
Remember,
can be in the habit of the practice of doing that. Ask them for their
yeah.
EIN number. And they can't lie because they're
Mhm.
under ooth. And it's the
Yes,
best
and
place to
answer
ask them
court,
But
for it.
she
court
also
of
said,
record.
wait,
That's why
she
if they say
also
no to
said,
you,
she also said, or the W9.
yeah.
Well,
And
the
if
no,
they
the
lie to
W,
you and
the,
tell you you can't get it, then you know something is up, right? So
Mm-hmm.
the Treasury now will go after them and they fine them. They give them a fine. If
I couldn't never the water down my bike. Merciful.
too. But then I was like trying to get home. I was like, forget it.
Yeah,
Yeah.
the one with we're trying to give you we're give you the ticket, right?
Well, you made me blow into that thing, that void. What do you call it? Like, I've never done
Breathalyzer.
The
It's a breathalyzer
breathalyzer.
test you did, right?
I've never done one of those things in my life. And I
That man
told
is
him
a piece of crap.
he's a piece of crap. And I'm like, I've never done those things in my life. I even told him, so his camera's got that there. I've never done one of these in my life.
Did you have a camera? Did you have a camera for yourself to protect you from these criminals?
No, because I know what to do with them if they try me.
Mm-hmm.
I know what to do with them. Like since I found out about this W4, I don't worry about nothing they do.
For real, for real.
Yeah, we have to have some remedy. We need to focus on remedy. We can't keep dwelling on the problems.
And every
It's not
time people
healthy.
do it, and when we do that, we shut them down.
We
This is how
can't
we
keep
force
dwelling
them.
on problems.
Yeah, this is how we force them to be lawful.
Yep, yep. We have to.
Yeah.
All right. So it's getting late. I have to ensure my son is in bed. So it was a very good session. I'll get myself prepared, and so we can, have another good session. So
But
good
as
night,
more,
everyone.
you guys shouldn't be going to their court. You should only be going to Supreme Court, if anything, right?
Yes, and that's what I always tell everybody. Don't go to their state court. I always try to bring it to the federal because the federal takes things more serious than the crooked little state court.
Yeah.
Not supposed to go to any of their courts. You're supposed to just file your paperwork because we're international. We're not part of their jurisdiction, so we can't be confused. Right. So we should just file our paperwork with the clerk and avoid their court at all costs.
When you go to the state court, that's when you see the real corruption. You want to remove your case. Even the lawyers here sick and tired
That's
of
why
the
you
corruption.
W4 them to shut them down, make them go sit down. They're just trying to make money off of you, capitalize.
Yeah. It's terrible. It's a terrible situation.
So is there any testimony of W4 where
many
people
did
many
people they come in?
people?
Yes,
I'm
they
still
have
waiting. I
5,000
sent mine
people.
in.
Oh, you sent yours in, Tony?
Yeah, I did the Equifax. I just sent for my what's the other one name? TransUnion.
Uh-huh.
Yeah.
I just mail for my information.
Oh wow, that
yesterday.
was quick.
Wait, Tony. So what you do is you call like TransUnion and Equifax and ask them for your report.
Yeah.
Yes.
Oh, and they mail it to you.
Yeah. Yeah.
Oh, okay. All
Tony,
right,
did
I'm
you
And
gonna
get
then,
do
caught?
that.
yes, I
And
did.
then
You
and then
did.
after you get
were
it,
in
no.
there, weren't you? I knew I saw you in there.
And then after you do that, Tony, then you do the W4.
Yeah. Did the W4 and there's what did one again? The 1040. And then the 1040 is just a voucher for them to get paid.
Okay, so you did 1040 V1040 and W9 to
But
get
there's a
the
specific
No,
thing
the
you have to do
the
with insurance.
W9 is for you to get the information from the companies,
Yeah.
and you find
from
the
the credit
EIN number
company.
on
Number
it.
as well. That's why it has the EIN number in there, the
In
W9.
there, yeah.
So you use the W9 to get the credit report.
No. You don't need it for the credit report.
Oh, okay.
Only the
It's always
court.
for example, if you're going after the brick, you ask the brick for their W9.
Okay.
Yeah.
And the W9 will have the EIN number in it.
Yeah.
Oh, okay.
And then you
And
put
that's
exemption and boom, you send it off to the treasury. But if you're doing a identity theft, then you're gonna have to apply for a PIN.
separately, yeah. I did that too.
You did you ordered your IP PIN already? Oh,
Yeah.
you ain't playing. Oh my goodness.
Okay.
Yeah, that's to shut down the SIM card.
Okay. Yes. But is it a wise idea though to shut down your SIM card when your estate is attached to so where that leave you when there's the system?
No, anytime anybody wants to use it, you have to have your PIN number. You have to give it your PIN.
You have to authorize them.
It's just like your bank card.
Oh, okay.
Yeah.
Because I'm wondering if it's going to exclude you from the system, and then you end up, not, you can't live.
No, it's just for the IRS.
IRS.
Ah.
Basically, only you and IRS would have access to it without permission.
Wow. Okay. I was concerned about that.
Yeah.
I think I'm gonna do the course.
Oh.
Or yeah, it's interesting.
But when you're doing it though, make sure you record it.
Record it, yeah.
Okay.
So you can always go and review it.
Oh,
Where do you get that? Where do you get that course?
It's in the States.
Okay, but Tony and Kamisha can conduct. Why are you on?
That's some biggie. That's some biggie.
And offer it. And offer it for your time. And Tony collaborate.
Yeah.
Instead of those white people making all that money, let's just everybody come together and we teach them.
Yeah.
Right? I don't mind.
Instead of paying, we give it to you.
I don't mind. I give it back to you.
Give it back to you guys. Because you guys did the course.
Hey, Tony.
Well, Willie,
so you and Kamisha,
Willie was talking about something like that at one point. I don't know if what he's doing.
Willie,
I start my group, but I have just been working so assiduously on all of my pointers so that I can get all my stuff done before I start doing it with people. And my problem is I have not covered all my bases because, like, for instance, going through the proclamation and the declaration, that's what I'm working on. But it have a lot of overlapping errors. Like they call in it sometime when they say the United States, they should say the United States of America rather than and the person and the individual, and they just mix up. So I have to go through it, take out all of the errors, correct it before I can send that off, and that's one of the process. Then the trust and the this and the that. It's just a lot of things, man.
Yeah. Well, this W4 thing, Kamisia, I will do a one-on-one with you with this. So you walk me through the process, and I will, instead of giving these people that $50, whatever, I'll give it to you.
Tony, I started a group, so if you don't mind, I'd like to add you so we can run the courses together.
No problem.
Yeah?
That
Okay.
W4 thing, I recorded the class that I did with them, so I have it somewhere there on my YouTube channel in private. Sorry, not public.
All right. So can you enroll me as well in that group?
Oh, sure.
The double
Yeah.
four thing there.
Absolutely. Yeah.
All right. You have my number, right?
No, I don't. Please contact me and message me on WhatsApp, and I'll add you.
Yes, in Prudence. All right, I will.
Okay.
All right, everyone. Have a good night. It was a good session. Yeah, so we'll meet again next Wednesday. We'll come prepared.
Yes,
Paul,
attorney.
Attorney, thanks for your
Janet,
time.
Attorney Leslie, please come prepared.
Yes,
I'm
we'll definitely come prepared.
All right. It was
Okay,
a
then.
pleasure speaking to you, Tamisha.
Well, thank you likewise.
I'm glad you stand your grounds with that crazy officer. So, yeah, them people, them sometimes them try to get over you. If you stand your grounds, they will try to harm you. So,
oh yeah.
All right.
Take care, everyone, and don't forget you guys.
All right,
have
then.
your
Okay,
homework.
then. Bye.
Yeah.
Good night.
Good night.
All right.
Hi
take
guys,
care.
have a good one.
Bye bye.
All right.
Recording.
Yeah, put it on there. Jordan, you'll be just fine. Don't make nobody scare you into thinking that you're sick. You're not sick. Okay? You just have a little challenge. That's it. Okay? Yeah, you'll